Ms. Chia Yong.
Thank you, sir. May I declare my interest as President of SPD and Board Member of SG Enable, both serving vulnerable persons. The Vulnerable Adults Bill seeks to safeguard vulnerable adults from abuse, neglect, and self-neglect. Everyone has the right to live in safety, free from neglect, abuse, free from fear and coercion. This is so whether the person is powerful or vulnerable, has or does not have mental capacity. This bill has been a long time coming, and I'm glad it has finally come. This is a good start, but I'm sure the Minister will agree with me that there will be more to be done to protect vulnerable adults. This bill has been a long time coming because it touches on sensitive matters. A person's right to live where he chooses, a person's right to be cared for, a family's right to care for a vulnerable adult. When we enter into sensitive family space, we can expect to deal with deep-seated family tensions and grievances, strong and overwhelming family dynamics, family reputation, strong ties of love, loyalty, kinship, and obligation, feelings of guilt, resentment, contempt, financial challenges, emotional, relational dysfunction, misguided action or inaction. And very often, many, if not all, in one set of relationships. So understandably, the government doesn't want to be interventionist. And understandably, my honourable colleague, Ms. Sylvia Lim, also cautions quite wisely against an unjudicious exercise of power. And yet we need to strike a balance against the right of another person to act as opposed to the need to protect the vulnerable. And this balance must be prudent and yet bold, and it must be struck in favor of protecting the vulnerable. If I may share that this could well be a difference in perspectives. A few years ago, someone shared with me from the social service sector that in the earlier years, when there were voices calling for transport concessions, there were people in the social service sector serving people with disabilities who opposed those voices. In their view, it was the dignity of people with disabilities that mattered more. That by virtue of upholding that dignity, we should not concede and ask for transport concessions. Strangely, the person then shared that when the government announced these policies and they consulted people with disabilities, the people with disabilities said they wanted it. So it just could be a matter of perspective, is it not? We could be professionals and we could be very well-meaning and say, we want to preserve your dignity. But if I'm a vulnerable person, maybe I want more to be protected. It is, I suppose, a balance and an assessment that the government and the professionals have to assess, have to make. But again, I urge, it must be struck in favor of protecting the vulnerable. Let me now come back to the issue of sensitive family space. When a stranger enters into any family space, he or she will be confronted with the question, who are you? What it really means in our context is, what right do you have to intervene in my family affairs? What right do you have? Currently, not much right. And hence, social workers, support service providers, government officers, while actively engaged on the ground to assist and support vulnerable adults and their families, are hampered in their attempts to protect such adults. Not much right. There's not much that can be done, and hence we welcome this bill. Take another step back. No one in our right mind or heart will ask, what right have you to protect the vulnerable adults? But we should not indeed be surprised that family members will demand, what right have you to interfere in my family matters? And that is a very fair question, and that is a question that must be answered by this House, now, unequivocally. We must answer this question clearly and unequivocally by, firstly, setting out clearly the scope of the protection for vulnerable adults. Anyone whose circumstances do not fall within the scope of protection will not be able to claim such protection. So I think it's got to be clear in our minds that we must have a bill that is broad enough to protect. The protection must be sufficiently significant to an adult. Secondly, we must empower the director, protector, and others to act boldly and courageously to protect vulnerable adults without fear of complaints, fear of having to put out so many reports to explain their decisions. Despite Section 34, clarity on the scope of protection and a strong adherence to the principles set out in Section 4 will empower the director and such persons to act boldly and courageously to protect the vulnerable person. And thirdly, persuading the community that each person has a role to play in the protection of vulnerable adults. These three questions we must answer unequivocally today. So, a vulnerable adult is defined as an individual who is 18 years of age or older and is by reason of mental or physical infirmity, disability or incapacity incapable of protecting himself or herself from abuse, neglect or self-neglect. Perhaps one day I will apply for protection. Let me first address the scope of protection, but I will address the first two issues together. The issue of the definitions and the empowerment of the director and the protectors. Both issues relate to the scope of protection, and I will share my views as to what I think the limitations in certain definitions are, and state my proposals for amendments. In the interest of time, however, I will not repeat definitions word for word, and I seek the indulgence of honourable members to refer to the bill as I speak. So abuse has been defined to mean physical abuse, emotional or psychological abuse, conduct or behavior by A that in any other way controls or dominates B and causes B to fear for his or her safety or well-being, or conduct or behavior by A that unreasonably deprives or threatens to unreasonably deprive B or B's liberty of movement or well-being. So, emotional or psychological abuse is further defined. But I have to admit, I'm not comfortable with the word mean or means in that definition. It limits the definition as opposed to the word includes. And when I read the definition of emotional or psychological abuse, together with the illustrations, I believe, sir, that the question is left open as to whether non-action, such as indifference or just complete inaction in treatment, constitute emotional or psychological abuse. And I hope the Minister can clarify. I move on to the definition of neglect. It means the lack of provision to the individual of essential care to the extent of causing or being reasonably likely to cause personal injury or physical pain to or injury to the mental or physical health of the individual. Again, the word means, very limiting as opposed to include. Next, self-neglect. Also, it means the failure of an individual to perform essential tasks of daily living, to care for himself, resulting in the individual suffering certain prescribed consequences or conditions. At this point, I would like to propose that the Minister considers amending the three definitions by replacing means with the word includes. This amendment broadens the scope of protection and empowers the Director with clarity, confidence, and courage in the exercise of his powers to protect vulnerable adults. With reference to the definition of self-neglect, there are also other limitations. In order for the requirement of self-neglect to be fulfilled, the failure of the individual to care for himself or herself must result in the individual living in grossly unsanitary or hazardous conditions, or suffering from malnutrition or dehydration, or suffering from an untreated physical or mental illness or injury. The three consequences are extreme. At least one of the three must occur before the Director can intervene. In other words, the Director cannot intervene to protect the individual until something extremely terrible has happened. And that cannot be the intention of the Minister, and it certainly should not be condoned or be the intention of this House. The Director should have the power to intervene if the failure to care for oneself could reasonably be expected to cause any of those three consequences. In addition, I would also propose that the word grossly be deleted from Roman numeral 1 of the definition. It is bad enough to live in unsanitary or hazardous conditions. We should not require such living conditions to be gross in order to satisfy intervention. The deletion of the word grossly will also remove ambiguity as to whether grossly qualifies only unsanitary or qualifies hazardous as well. So, as I said earlier, definitions are important. The narrower the definitions, the narrower the scope of protection. So I urge the Minister and this House to consider my proposals. I now move on to three aspects of the protection. Firstly, the removal of the vulnerable adult from his place of residence for assessment. This is provided for under Section 6. However, again, the definition of assessment seems somewhat limited to me. It is not clear as to whether psychological assessments are included, and I would be grateful if the Minister can clarify. If indeed assessment does not include psychological assessment, then I urge the Minister to consider amending the definition to include the same. And notwithstanding that there may be many non-legal triggers for the protection of a vulnerable adult, assessment itself is an important trigger. Beyond re-examining the definition of assessment, we should also re-examine the requirement for a court order where a vulnerable adult, notwithstanding his or her mental capacity, refuses under coercion to give consent for his or her removal for such assessment. So given that I have similar considerations and arguments in relation to Section 6 and Section 10, I would like to make my submissions on both sections together. For the ease of recollection by members, Section 10 empowers the Director to remove a vulnerable adult from the place where the vulnerable adult is residing or staying if the Director is satisfied on reasonable grounds that the vulnerable adult has experienced or is experiencing or at risk of abuse, neglect, or self-neglect. Unfortunately, it also requires an order of court where a vulnerable adult, notwithstanding possessing mental capacity, refuses to give consent for his or her removal. Two important considerations form the basis of my submissions on the inadequacies of Section 6 and Section 10. 1. Where the individual or vulnerable adult does not give consent, but is also not acting freely. For example, where he or she refuses consent for fear of reprisals from or unhappiness of caregivers or of family members. Secondly, there is also a spectrum of abilities in reasoning and judgment. Under the bill, the mental capacity is used in the same sense as under the Mental Capacity Act. This leaves a large group of persons who may have inadequate reasoning faculties, but who may not lack mental capacity under the NCA. For example, those with low intelligence or suffering from certain spectrum of ASD or in the early stages of dementia. In both groups, the lack of financial independence, lack of social support network, and emotional attachment to familiar people, the Stockholm Syndrome, may increase their dependency on family members or increase their fear in reporting. We know that it is common for caregivers to refuse medical assessment. This is a problem that we need to address. So we cannot assume that these two groups of people do not require protection simply because they have refused to give consent. So I support the provisions, in fact, that the director may, without the consent of the relevant donee or deputy, assess a vulnerable adult without mental capacity, recognizing that some donees or deputies are themselves abusers. But here, the two groups of persons whom I referred to above are no less vulnerable than those who lack mental capacity. In fact, they could be more vulnerable simply because they have the capacity to consent. And should they give consent, or should they in any way intimate fear or convey or imply a need for protection, they are more likely to be held to account by their abusers, caregivers, and family members. The abuse or neglect may intensify, family alienation may deepen, the fear of the vulnerable adult is thereby accentuated. I have noted that the bill provides for the director to make an application for court to the court for the vulnerable adult to be removed, whether for an assessment under Section 6 or for removal under Section 10. I submit that the director should be given broader powers than to be constrained in this manner. My reasons follow from my analysis as to how a court order may be obtained for the assessment of an individual or a vulnerable adult. In a court application, first, the director must make the application to court. Second, the director must, A, satisfy the court that on a balance of probabilities, the individual or vulnerable adult has experienced or is experiencing or at risk of abuse, neglect, or self-neglect. And B, persuade the court that such an order for assessment is necessary for the safety and protection of the individual or vulnerable adult. Now, if the director is able to satisfy both requirements, should he not be empowered in the first instance to remove the vulnerable adult for the protection of the vulnerable adult? Any concern as to whether the director may be acting too intrusively may be addressed by amending Section 11(1)(b) as well as related provisions accordingly. If I may, I would like to share also an additional concern in relation to the removal of the vulnerable adult for assessment. Section 7(1) provides that the director is not required to exercise any power under Section 6 if consent is refused by the vulnerable adult with mental capacity. Making the application to court becomes discretionary. In other words, the director may choose also not to make an application to court.
Ms. Chia, you have 1.5 more minutes.
Thank you, sir. As such, I would propose the amendments that I have suggested, and I would also like to ask that the Minister considers other amendments, considers provision of facilities to cater to the needs of vulnerable adults. I also ask that we not be shy to exercise and to apply for powers of exclusion of the abusers. If I may also end, the role of the community cannot be underestimated. The case of NEE and other unfortunate cases tell us that there will be many out in the community who would have fallen through the gaps. Neighbors play an important role. They have, in some cases, played a critical role in saving someone. So I urge neighbors, it is better to report, to save a life or even a family than to report, to retrieve a body. Thank you. I support the bill.